Good morning, everyone. It's James from Quails here. Thanks very much for registering for and attending our webinar this morning on lawyer, mental ill health and legal ethics. Can I begin the session by acknowledging that the traditional owners of the lands on which we're dispersed, there are people all across Queensland tuning in today and indeed across other parts of Australia as well, so we welcome you. We acknowledge the Yagara and Turrbal people in Brisbane, where I'm speaking to you from, also the Wurundjeri people of the Kulin Nation in Melbourne, where our speaker, Michelle Sharpe, is based. For those that haven't used this technology before, just a couple of housekeeping things. We would ask you generally to hold your questions until the end of the presentation, and there's a couple of ways that you can ask those questions. One is to press a button that looks like a hand, and we'll see your hand come up, and we'll be able to unmute your microphone and you'll be able to speak. I'll just get some of you to press that hand now to make sure that you can find it and to make sure that you can hear me. Terrific, thank you guys, that's coming through really well. The other way to ask questions is to type a question into the questions box in your control panel there. That's kind of all you really need to know in terms of driving this technology, so I might just quickly introduce our speaker. Dr. Michelle Sharpe signed the Victorian Bar Roll in November 2002 and practices in Victoria in the areas of commercial and regulatory law. She's lectured at the University of Melbourne in the areas of legal ethics, civil procedure and contract law. Her PhD thesis looked at duress, undue influence, unconscionable conduct and statutory unconscionable conduct, but for our purpose today, Michelle is recognised as having a keen interest in health and wellbeing issues affecting the profession, particularly impacts on legal ethical conduct, which makes her a great speaker to talk to us today about lawyers' mental ill health and legal ethics. So welcome and thank you to Michelle.
Thank you very much for that introduction. I should also add a little something about, or expand upon something about my interest in this area. Back in 2007, I was increasingly concerned about some of my colleagues here at the Victorian Bar and pushed for the creation of the Victorian Bar's Health and Wellbeing Committee, with which I've been very much involved, and now over the last couple of years have actually chaired that committee. So that's really fueled my interest in the area of mental ill health in the profession, as well as in particular the regulation, how it intersects with the regulation of lawyers. So my paper today has three rather modest aims. It is to look at the ways in which mental ill health may disentitle or restrict the ability of a lawyer to practice law. Then to go on to consider what duties lawyers might have to notify a regulator of their own ill health. And then, rather more controversially, the duties that practitioners might have to notify the regulator of another's ill health. I'll also go on to consider how the issue of mental ill health or of practitioners is typically managed by the Legal Services Commissioner, what sort of powers they have, and also how the courts approach the issue of mental ill health when disciplinary complaints are brought before them. Of course, to begin any talk on mental ill health on the profession, I think you first need to look at what the statistics are on mental ill health, to have an appreciation of why this topic is so important, why each of us, I think, need to know what our professional obligations are with respect to ourselves and potentially others. First, looking at the Australian research, and that's fairly recent research. In the United States, they have been researching lawyers and law students since about the 1950s. I'm sure there's a joke in there somewhere about researching lawyers. It just escapes me just now. But in Australia, we really only started to look at this issue and research this issue really since 2007. So in 2007, Beaton Consulting, which every year issues an annual professions survey, in 2007, in conjunction with Beyond Blue, added a few questions about mental ill health in their annual survey of the legal profession. I spoke to Margaret Beaton, who said she didn't really think too much of it at the time. She just thought, wouldn't be nice, why don't we just add a few questions? And they were very surprised at the result. What they found was that the legal profession, or lawyers, are 1.5 times more likely to suffer from depression than the general population. They also found that 5% of the respondents were using drugs or alcohol to cope with feelings of anxiety. That then seemed to spark a great deal of interest in the subject of mental ill health in the profession, certainly in the general media. And in 2007 there was a Macquarie University study, and that study really was only, the subject of that study really was only criminal lawyers. What they were particularly interested in was what's been called acquired post-traumatic stress syndrome, and they figured that criminal lawyers, given the nature of their practices and the traumatic material with which they have to deal in cases, were far more likely than civil lawyers, say for example who has what might comparatively be described as a genteel practice in property law, would have a much greater risk of developing acquired post-traumatic stress syndrome. The results of that survey also surprised them, because certainly they did find, as they expected to find, that criminal practitioners were at greater risk of developing acquired post-traumatic stress syndrome. But they also found that regardless of the area of law in which you practice, there was a heightened risk or a greater rate of using alcohol to cope with stress and anxiety. 2/3 of the respondents were using alcohol to cope with stress and anxiety, and 1/3 were using medication, were using drugs to cope with feelings of stress and anxiety. Then after that followed what remains, I think today, the largest, most comprehensive study on mental ill health and the profession, and that's the Brain and Mind Research Institute in 2008. And they surveyed law students, lawyers and barristers right across the country, and they found in that 1/3 of solicitors and 1 in 5 barristers surveyed were suffering from clinical depression, which indicates that depression in the legal profession at large is about 4 times higher than that of the general population. But perhaps just as troubling, the study also found that lawyers had certain perceptions and beliefs about mental ill health that were likely to create a barrier to seeking help. A number of the lawyers surveyed reported that they would prefer not to seek help if they were experiencing depression, and that even when help was sought from a professional, many lawyers surveyed thought that the most likely result would be there would only be some slight improvement. And even more concerning, most lawyers surveyed reported that they thought that people suffering from depression would be discriminated against by others. And just over half of those surveyed reported that they thought they would be discriminated against by an employer. Now, as I've said, there has to date been a huge amount of research on mental ill health in the profession, particularly as compared to the US. So I always think it's helpful to look at what's happening or has happened in North America to give an indication or a better understanding of the depth of the problem of mental health in the profession generally. Now, although some differences exist between Australia and North America in terms of legal education and the legal system, consistently, I think, when you look at the research, it closely compares to what research we have done in Australia. So, for example, looking at depression, a study was undertaken by Johns Hopkins University. It has yielded, I think, some similar results to studies in Australia. They found that lawyers were 3.6 times more likely to suffer from a major depressive disorder than any of the 104 professions surveyed. A study of lawyers in Washington found that 19% of lawyers in that state suffered from statistically significant elevated levels of depression, compared with 3 to 9% of people in Western industrialised countries. A study of lawyers in Arizona found that Arizona lawyers suffered from depression at about twice the rate than in the general population. Another study revealed that 37% of lawyers in North Carolina reported being depressed, and 24% reported suffering from the symptoms of depression, such as loss of appetite and insomnia, at least 3 times a month during the previous year. In addition to these higher rates of depression in the legal profession, studies have shown alarming levels of anxiety and other kinds of mental illnesses. One Arizona study found elevated rates of anxiety, hostility and paranoia among lawyers. And in the study of North Carolina lawyers, over 25% reported having experienced symptoms of extreme anxiety at least 3 times a month over the past year. The study of Washington lawyers revealed indicia significantly above the normal population among lawyers for anxiety, social alienation and isolation, obsessive compulsiveness, paranoia, phobic anxiety, and hostility. Studies in the United States have also shown that lawyers contemplate and attempt suicide at greater rates than the general population. The study of North Carolina lawyers found that 11% had thought about suicide at least once a month for the past year. One study of Washington lawyers reported that lawyers are more likely than the general population to think about suicide, and on attempting suicide, are more likely to succeed in killing themselves. One researcher, on reviewing the death certificates of white male suicide victims by the National Institute for Occupational Safety and Health, has suggested that the suicide rate for white male lawyers in the United States may be twice that of other white males. A study, I think, in Washington found that 26% of respondents used cocaine. Now, turning to the regulation of lawyers. So, as you know, I think most of you are Queensland lawyers. Queensland lawyers are regulated by the Legal Profession Act of 2007. And under that Act, Section 46 of that Act in particular provides, well, in order to be admitted and, of course, in order to hold a practicing certificate, you must be a fit and proper person. And the Act refers to suitability matters in determining whether somebody is a fit and proper person. And those suitability matters include whether the person currently is unable to satisfactorily carry out the inherent requirements of practice as an Australian legal practitioner, which I think, frankly, is a more enlightened definition than the definition in the Victorian Act, or what used to be the old Victorian Act, which I think read whether or not somebody currently has a material mental infirmity. Here is, there's no reference, which may import stigma to mental ill health. It's just whether a person is currently able to satisfactorily carry out the inherent requirements of legal practice. And I've emphasised or put in bold currently, that's my own emphasis, because when we talk about disclosure, that's relevant to consider. The test is whether you are currently able to hold, to be admitted, whether you're currently able to hold a practising certificate. Now, the Legal Profession Act, the LPA, provides for health assessments to enable the Legal Services Board, Legal Services Commissioner, to determine whether somebody is fit and proper, whether they're able to carry out the inherent requirements of legal practice. Here in Victoria, we have a mental health policy, which also guides practitioners in determining what issues might mean that they fall outside of the fit and proper person test. That's not the case here in Queensland, although if you do go to the Legal Services Commissioner Queensland site, there's lots of very helpful resources and papers addressing the topic of mental ill health. So on the issue of health assessment, if the regulator finds, whether the regulator has reasonable grounds to believe that an applicant is unable to carry out the inherent requirements of practice, the regulator can compel the applicant to undergo health assessment to assist it in determining whether the applicant is indeed a fit and proper person. Under the Act, it's the regulator that bears the expense of the health assessment, and the regulator may appoint one or more qualified persons to conduct the health assessment. And as I've said, the mental health policy in Victoria makes it quite clear that the regulator is only concerned with a current mental illness, and it's not concerned, they are not concerned with a current mental illness that is being effectively managed. The Queensland regulator doesn't set this out in any clear policy. They have on their website issued a helpful policy where they say that they have a supportive approach to dealing with mental ill health with practitioners, and also where there are disciplinary complaints. And I've certainly seen and read many papers where the Queensland Legal Services Commission certainly seems to have a fairly enlightened approach to the issue of mental ill health. But if one turns, as I say, to the definition of fit and proper person, it's quite clear that there's a requirement that if there's an issue of mental ill health, that it has to be current. It's irrelevant if it's a historic issue. And I think your definition perhaps is much more helpful because, as I say, it deals with the inherent requirement of practice, which would seem to suggest that it's almost not necessary or not needed to have a policy which spells out that a regulator is disinterested or it's not relevant if that health condition is being effectively managed. because necessarily if it's being effectively managed, then that person is then able to carry out the inherent requirements of practice. Moving to the case law, that approach, or that my interpretation of the Act, it is, I would argue, consistent with the case law. Cases where an application has been brought on a complaint about a practitioner for the removal of that practitioner from the role of practitioners, and one of those cases is a Western Australian case of the Legal Profession Complaints Committee and a practitioner, and that's a 2010 case. And I'll give you the reference if you're interested in reading it further. That's square brackets 2010, Western Australia Supreme Court, so WASC at 13. And that case involved a young solicitor who'd been admitted to practice on the condition that she authorised her treating psychiatrist to provide the Western Australian Legal Practice Board with reports as to her condition every 3 months. On seeking admission, the solicitor quite properly disclosed that she had been diagnosed as suffering from a bipolar disorder and borderline personality disorder. Within a year of being admitted, though, the solicitor was found to have forged 2 medical reports that she sent to the board in fulfilment of the conditions on her practicing certificate. The court found that the solicitor's conduct was closely associated with the psychiatric conditions from which she suffered. The court concluded that the solicitor was not a fit and proper person to practice, and that her name should be removed from the role of practitioners. The court, however, did go on to note that should the solicitor's psychiatric conditions subside, that it was not beyond the realm of possibility that the practitioner might be readmitted. Two cases in which practitioners have been admitted or readmitted after having recovered from a mental illness are Stokes, and that citation is square brackets 2008 WASC at 269, and XY in the Board of Examiners. That's reported at square brackets 2005 VSC at 250. In Stokes was a barrister who was struck off the roll after having engaged in a range of instances of repeated unprofessional conduct. Stokes' conduct arose out of a condition described by his treating psychiatrist as a personality disorder producing avoidant behaviour. On seeking readmission, Stokes produced medical evidence that he had recovered from his illness and was in good mental health. The court accepted this evidence and Stokes was readmitted. The court, in reaching this decision, observed that obviously the community must have confidence in the capacity of those who are admitted to practice law. The authorities responsible for the regulation of the profession and the court must be vigilant to ensure that the public is protected from those who lack the capacity for whatever reason, including mental illness. However, where the court can be satisfied by evidence that the incapacity, which resulted in appropriate steps being taken to protect the community, is no longer present, it will equally be in the interests of the community to take steps to enable the practitioner to resume the delivery of services. Similarly in XY, XY was a young solicitor who was admitted to practice after the court accepted her evidence that she was no longer suffering from a mental illness. XY had been sexually abused as a child and had gone on to heavily abuse alcohol and engage in other self-destructive behaviour. XY was later diagnosed as suffering from a borderline personality disorder with impulsive, disruptive behaviour and self-mutilation risk, and received medical treatment. Despite her mental illness, XY managed remarkably to complete her law degree, and quite well if memory serves. At the time she sought to be admitted to practice, XY was able to produce to the court medical evidence that she was no longer suffered from a mental illness. Moving on, a duty to self-report. I've referred there to what are the old solicitor rules that's now been eclipsed by the uniform rules which were introduced in June of this year. As I've indicated, there's a requirement to be a fit and proper person to hold a practicing certificate. So it would follow that for Queensland lawyers, that if you find yourself in a situation where you become unwell and that you are unable to manage that illness, then there is a duty to inform the regulator and to cease practice for the time until you're able to recover from your illness before returning to practice. Or alternatively, to cease practice for a time until you're able to recover and you're able to become well. And as I've said, the Legal Services Commissioner of Queensland has indicated on their website that they take a supportive approach with practitioners, supporting practitioners during that time and supporting them in their return to work. And again, rather helpfully on the Legal Services Commission of Queensland's website, they include a whole host of a list of resources that you can turn to or have access to in assisting you in recovering or dealing with any issue of mental ill health. But when talking about a duty to disclose an instance of mental ill health, I always think to myself, it's kind of ironic. It's a bit like the joke they make about Alzheimer's, and that is, if you think you suffer from Alzheimer's, or you go down to your doctor and you say to your doctor, look, I'm concerned I might be suffering from Alzheimer's or some kind of dementia, the joke amongst I know amongst general practitioners is that if the moment you suggest that is a fair indication that you don't suffer from any of those things. And I think that joke is equally applicable to practitioners who suffer from mental ill health who then go on to disclose. I think if you've got enough insight to consider that you might be unwell, enough to prompt you to approach a regulator and suggest to a regulator that perhaps you might be required to disclose that illness, I think is a fair indication that you are managing that illness and that there is no requirement, in fact, to disclose that illness. I think that a much greater concern are those illnesses that are not disclosed, and principally, I think mental ill health is not disclosed because people may simply be too unwell to have the insight or ability to seek help, much less to disclose the existence of the illness to a regulator. Also, as we know from the Brain and Mind study, practitioners may have negative and fearful attitudes to mental health, and those attitudes may create a barrier to the practitioner disclosing their illness or even seeking help. So in those circumstances, and frequently what I see is Chair of the Health and Wellbeing Committee and also as someone who has a keen interest in these issues, are instances of practitioners continuing to practice law until such time as they do something, or there is a disciplinary complaint that attracts the attention of a regulator. Alternatively, it might, alternatively, certainly at the Victorian Bar, a colleague of a barrister might, approach somebody within the bar, such as myself, concerned about the ill health of a colleague, which then enables, enables myself and others from the Victorian Bar to provide services or to provide support to that practitioner, thereby stepping in at a time where and providing support at a time that might head off that the mental health issue deepening, or a disciplinary or an issue arising as a result of that illness, and a disciplinary complaint being made. But the question often gets asked, or the question often gets asked, is there a duty? Is there a duty of practitioners to report to an authority, or to a regulator, the mental ill health of others? While there have been, I've noted there are attempts by some legal ethicists, like for example Dalpont, to suggest that there might be an obligation. I think unfortunately, as much as I would like to see that obligation, I wish that obligation was there. It might mean if an obligation was there, there would be greater motivation for people to self-disclose or take action, or for services to be rendered to somebody who needs it, who doesn't have the insight. I have scoured the Act and looked through rules, and there isn't the obligation. The obligation doesn't exist. It suggested at common law that perhaps there is an obligation, there is this kind of general obligation at common law to notify a regulator of the unethical conduct of others. And for example, Dalpont refers to this case of Legal Practitioners Complaints Commission and Fleming. That's reported at square brackets 2006 Western Australian State Reports, WA SAT at 352. That wasn't a case of mental ill health. That was a case of a trust fund defalcation. And in that case, the tribunal held that, I think that was, yes, that was a case of trust fund defalcation, which is one of the few, I have to say, under the Act, is one of the few statutory obligations you have to report the conduct of another practitioner. But there, the tribunal generally noted that it is essential to the maintenance of professional standards and the confidence in the public in the largely self-regulated legal profession that where professional standards are not met and the matter cannot be resolved, the issue be referred to the appropriate authority. So as I say, there isn't this. If such an obligation does, as Dalpont suggests, exist in the general law, it certainly is not recognised in professional conduct rules or any of the legal profession acts. But I would hazard a guess that with the increasing regulation of lawyers and increasing awareness of mental ill health in the profession, these rules may well change. Indeed, the reporting of ethical violations is already mandated in New Zealand, England, Canada and the United States. And in fact, I think largely prompted by the huge amount of empirical research into mental ill health in the legal profession, the United States American Bar Association, the ABA, has issued 2 formal ethics opinions in which the ABA details the ethical obligations of lawyers with respect to notifying the appropriate professional authority of mentally impaired, what they call mentally impaired lawyers in their own firms, and mentally impaired and other mentally impaired lawyers. In reporting other mentally impaired lawyers, that's an unfortunate term, but that's the term that's used in the opinion. The ABA opinion states, because lawyers are not healthcare professionals, they cannot be expected to discern when another lawyer suffers from a mental impairment with the precision of, for example, a psychiatrist, clinical psychologist, or a therapist. Nonetheless, a lawyer may not shut his eyes to conduct reflecting generally recognised symptoms of impairment, e.g. patterns of memory lapse or inexplicable behaviour not typical of the subject lawyer, such as repeated missed deadlines. So the ABA opinion advises that a lawyer, in determining whether another lawyer is mentally impaired, might consult a health professional and/or a lawyer assistance program for advice. The opinion also encourages the lawyer to raise his or her concerns with the impaired lawyer and/or the impaired lawyer's supervising partner. The opinion warns, however, that if these concerns are not taken seriously and the impaired lawyer continues to practice, then the lawyer has an ethical duty to report the impaired lawyer to the appropriate professional regulatory body. If the lawyer becomes aware of the impaired lawyer through the representation of a client, then, although that knowledge is unlikely to have been obtained through protected or privileged information, the lawyer must first get the client's consent before reporting the impaired lawyer. If the impaired lawyer is a lawyer in the firm, the ABA opinion makes clear that the firm's paramount obligation is to protect the interests of clients, and that the first step is to confront the impaired lawyer, to insist that measures be taken to ensure that the clients are adequately represented despite the lawyer's impairment. This opinion notes that this might include forcefully urging the impaired lawyer to accept assistance to prevent future violations or limiting the ability of the impaired lawyer to handle legal matters or deal with clients. If the partners of the firm reasonably believe that the illness is a short-term one and the lawyer can competently represent clients, then the opinion states that there is no obligation to report the impaired lawyer. Similarly, there is no duty to report if the firm is able to eliminate any risk to clients through close supervision of the impaired lawyer. The opinion makes clear that there is an obligation to report the impaired lawyer where the impairment renders the lawyer incapable of competently representing clients and where the impaired lawyer nonetheless continues to practice. To the extent that this disclosure might involve the disclosure of client competences, the firm must first obtain the consent of the client before making the report. The ethical obligation to report lawyers is taken seriously in the United States, and breaches of that obligation have resulted in disciplinary action. The rationale for the ethical obligation includes that enunciated in Fleming, in Australia, being the importance of upholding professional standards, and that, as recognised by one US judge, quote, no one is better suited to recognise a breach of the rules or better situated to observe one. So moving on to the consequences of mental impairment, or if there's been a disclosure to a regulator, the regulator may do a number of things. The regulator may not take any further action. The mental health policy by the Victorian Services Commissioner, makes the point that there are some mental illnesses which may have no bearing on a lawyer's ability to practice. There are, and many may come to mind. I can think of a partner of a national law firm when I was a junior solicitor who suffered from a terrible phobia of elevators, and a great deal had to be organised to ensure that he had an office that he could get to by stairs, or if he had exposure to an elevator, it was only for a very short period of time. Now that's clearly a mental health issue, but not one that would have any bearing on that partner's ability to practice law. And of course, there are depression is very common in the population, even in the general population generally. In particular, depression and anxiety is known to occur at even greater rates, for example, amongst women generally in the profession. But of course, there are many different degrees of depression and anxiety, and there are many ways that that can be managed. So, depending on the mental health issue, it might be of a kind that has absolutely no bearing on a lawyer's ability to practice law. And if that's the case, then a regulator typically, and quite rightly, will not take any further action. If, however, that mental health condition or illness is one that can have a bearing on a practitioner's ability to practice law, the regulator can do a number of different things. Now, what are the kinds of conditions that might have a bearing on an ability to practice law? Well, again, typically it's the kind of illnesses that are not being managed or have some difficulty in terms of managed, and there we're talking about particularly severe types of mental health issues. So the Victorian Legal Services Commissioner helpfully points out it's usually severe kinds. For example, schizophrenia. So where there are issues in terms of if it impairs your ability to think coherently, then that's something that potentially is something that a regulator would like to be made aware of, and on becoming aware of that, and after taking or considering any reports from a treating health professional, and here in Victoria, and I imagine it'd be much the same in Queensland, that the regulator will, before turning to any or exercising any powers that it might have in terms of a health assessment, will first and foremost consider or be guided by any reports provided by the treating health professional. On reviewing those reports, may do one of two things. It might accept an undertaking from the practitioner, or place a condition on a practicing certificate. Again, I speak to Victoria because that's the jurisdiction I know well, but again, I can't imagine that the position would be too different in Queensland, particularly from what I've read, and that is that the regulator typically will accept an undertaking, and will only place conditions on a practicing certificate in some of the more extreme cases. And those undertakings or conditions might include such things as for example, regular reports being provided to the regulator, updating the regulator on the practitioner's mental health. It might also include, for example, that the practitioner remains involved and committed to a 12-step program. It might also involve ongoing counselling for that practitioner. So it may involve a whole range of things which are really designed to support that practitioner to enable them to meet the fit and proper person tests, and also eliminate the risk, obviously, to the public in providing those services, because you know, as the cases demonstrate, that if somebody is able to practice law, then the community ought not to be deprived of these services. In the very extreme cases where the regulator considers that can't be done, the regulator may refuse to grant or renew a practicing certificate. Now, so what happens if, which unfortunately tends to be the case, that somebody suffers from mental ill health, they don't have the insight to access help to manage the condition, they have the insight to make the disclosure to the regulator, who might take steps or otherwise help support them in that, you know, at that time. No colleague steps in either to, you know, assist or perhaps make a phone call to a regulator, which might also act as something of a circuit breaker. As I've said, then often, sadly, in those situations, practitioners will keep up the facade that everything's okay, keep practicing law until something occurs and it crystallises in a disciplinary complaint being made against them. In Victoria, where the Legal Services Board, Legal Services Commissioner, with the Legal Services Board becomes aware of it, in Victoria they may defer enforcement or compliance action and enable the practitioner to recover, to get well. If there's a disciplinary complaint, here in Victoria, the Legal Services Commissioner really has no discretion. The Commissioner really has to act on the complaint. Where an application is made for the removal of a practitioner from the role, the response to the court is really quite mixed. In the case of the Legal Practitioners Conduct Board and ARDLIC, and it's reported, that's a South Australian case, that's reported as square brackets 2005, SASC at 478. There the court held that the mental illness of a practitioner, which may cause or contribute towards his commission of acts constituting unprofessional conduct, cannot excuse the conduct, but may be a mitigating circumstance in considering what disciplinary orders should be made. And that seems to be the orthodox approach. It's certainly also the orthodox approach here in Victoria, that it's not something that's taken into account when determining whether or not there is unprofessional or misconduct, but it's certainly something that's taken into account in mitigation of penalty. Perhaps quite rather controversially, in New South Wales, the in the case of the Council of the Law Society of New South Wales and K, which is reported at square brackets 2009 New South Wales ADT 139, and I'll refer you in particular to paragraphs 55 and 56. There, the tribunal refused to follow Ardlich and held that the solicitor could not be found guilty of professional misconduct by reason of his mental state, but of course that because of his mental state, found that the practitioner was not at that time fit and proper person to practice, and made orders removing him from the role. Now you may ask, well, what's the difference? The ultimate result was the same, however controversial K was. But I would argue that there is, there is quite a difference, and that is that on reapplying for admission, the practitioner in K really need only refer to the decision and then provide proof that he is now recovered and he's well and that he is a fit and proper person. The practitioner in Ardlich, however, will need to go back and explain how the conduct arose out of his mental ill health before going on to explain how he's now recovered and he's able to be a fit and proper person. And I think that distinction is important not only in terms of the challenges on seeking readmission, but it's a more compassionate, I think, realistic and more compassionate response that may well encourage practitioners to be forthcoming about their mental health. So I know at the time I think I'd like to wind it up there and allow for questions, but if I can conclude by making this observation, mental ill health is endemic in the profession. I think the research unarguably shows that. So lawyers need to be aware that if they fall ill and the illness is not being effectively managed, then they have, arguably they have an obligation to disclose the illness to the LSB, or to a regulator, on seeking to renew their practicing certificate or when they continue to practice law. Lawyers should also be aware that an obligation to report the illness of other lawyers to a regulator exists in other jurisdictions. And it is possible that as an awareness of or concern for mental health in the profession grows, that a similar duty may come to exist in this jurisdiction, or at the very least, increasingly the legal community, if not the general community, will be asking the question of why nothing was done when a mentally ill practitioner either to take steps to end their own life in a rather public fashion, which has occurred in Victoria, or when that results in some kind of misconduct. So, if I could, then, if there are any questions, I'd be very happy to answer them.
Michelle, can I thank you for a really thorough presentation that kind of canvassed a lot of really important issues for those of us in the profession for whom this can be an issue. A reminder, folks, that there are a couple of ways that you can ask questions. You can press that button that looks like a hand, and we'll see your hand go up, and you can you'll unmute your microphone and you can ask your question that way. The other way is to type a question into the questions box on your control panel. Thanks, Atul. Atul?
Well, certainly, given that you're mostly in Queensland, I think I'd certainly love to ask a question of you all, and that is my impression of Queensland right in that you're somewhat more enlightened than us here in Victoria in your attitudes to mental ill health. we have a fairly draconian approach, I think, in terms of disclosure of mental ill health. All people seeking to be admitted to the legal profession have to are exhorted to make full disclosure of any mental health issues, including historic issues, and I know that there have been some outdated views expressed about mental ill health by some within our profession. Am I looking across the fence and seeing greener pastures, or am I just imagining it?
I might have first crack at that. Excuse me. Michelle, it's James here. I'm not sure if he is best described as more enlightened or less concerned. I'm not sure if it's something to which our regulators and policymakers have turned their mind to anything like the extent that's certainly happening in Victoria and possibly to a lesser extent in other parts of the country. That's my sense. It's just kind of snuck under the radar a bit, but others might have different views.
Okay.
Greg, did you have a comment about that?
Yes, I do actually. I actually agree with you, James, mate. I don't think we are more enlightened up here. In fact, we normally look to Victoria to lead the way in a variety of things. Could I also ask, and it's not so much a question as an inquiry, unfortunately I actually missed the beginning of this very good presentation because I got distracted by other work commitments. Now I notice it's recorded. How does one access the recording?
I'll flick a link to that information to you, Greg, as well as hopefully a copy of Michelle's slides. Although
excellent, you're a very good man. I don't care what the others say.
I'm going to mute you now. And Maria, did you have a comment about that as well? And Maria, are you there? I did see a hand go up there. Guys, we are a little bit over 12 o'clock. Can I, on behalf of everyone who's tuned in from across Queensland and other parts of the country, thank Michelle Sharpe for, as I said, a really thorough and important contribution that really helps us understand some of the tricky challenges that can face us in the profession, which is, as Michelle kind of highlighted in a pretty scary way, massively overrepresented in terms of experiences of mental ill health. Thank you, Michelle. Thank you, everyone, for tuning in, and we will speak to you soon.
Thank you very much. Thank you for the invitation.